All right, Crim 4, let's knock out Chapter 9, Courtroom Evidence. This is kind of a long, kind of a complicated, and kind of a boring chapter. So we're going to kind of, we're going to get through it. So, introduction. Study of evidence is a study of the regulation of the process of proving facts. So, when we talk about evidence, when considering the penal code, like the California Penal Code, it is a book that is probably, 3 or 4 inches thick. There is also a book that is the Rules of Evidence. That is also another book that is about 3 or 4 inches thick. So you can imagine we are skimming just the ever so slight top of the rules of evidence and evidence as it pertains to the court process. But evidence is basically something that you're trying to prove a point with or trying to prove a fact with. So there are a lot of rules of evidence. We are not going to talk about a lot of rules of evidence. We're going to, again, kind of skim the top. Of course, as soon as I hit record, my dog goes right to the water bowl and starts slurping water. So if you hear some weird noise in the background, that is my dog. There are 2 kind of basic themes. The rules will favor inadmissibility of evidence. They kind of want to allow for evidence to come in, generally speaking, and the trial judge has discretion as far as the admissibility of evidence. Okay, so if there's a question as to whether or not some piece of evidence is going to be allowed in, generally speaking, the rules are going to favor basically for the defendant and for that evidence to be allowed in and for the judge to have discretion. Most states' rules of evidence are based on federal rules. They're based on the federal rules, but every state has different laws. A trial judge has discretion as to kind of make decisions. If that really thick book, like I said, of rules of evidence does not address whatever crazy issue is coming up in the court that day, the judge has basically discretion to make a decision, make a judgment call. And trust me, every single day that I sat in court during the 8 years that I worked in a courtroom, there was always a day when something would come up and I would be like, I've been here for 8 years. I've never seen this happen before. And we'd have to try and figure something out. And now my dog is coming and sitting next to me and licking my hand. So again, weird noises. I'm blaming it on Juju because he decided, of course, to come sit right next to me while I'm doing this. Just because the rules are construed in favor of admissibility doesn't mean that we have to trust that it's accurate. Oh, hearsay is probably one of my least favorite things. But a statement, first of all, we got to figure out what a statement is. Oral or written assertion or nonverbal conduct if a person if it is intended as an assertion. So let's say I am looking at you and I show you my hand and I'm only pointing my middle finger toward you. That would be nonverbal conduct. Would you take a message from that? Yes, you probably would, right? Okay. If a declarant is a person who's making that statement. So if I am the person who is holding my hand up, this is just for purposes of a nonverbal statement. That would be me. I would be the declarant who was giving you a nonverbal assertion. Hearsay. A lot of you know what hearsay is. You know your own definition of what hearsay is. A lot of us would say gossip, rumor, things like that. But hearsay, as far as the courts are concerned, is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Okay, so let me tell you what I mean. I'm going to give you an example of hearsay. I am in the classroom and I'm teaching class, and And one of you walks in and sees that I have fallen to the ground and I have a gunshot wound to my throat. And as I am starting to lose consciousness, I say to you, my husband did it. And then I lose consciousness and I die. Okay? Then you go to court. And the prosecution, who's charged my husband with murder, wants you to testify about what I said before I died. Would that be a hearsay statement? Absolutely. I said something, but I'm not there in court telling you. Why? Because I'm dead. But because I am not the one offering the statement, it's considered hearsay. Is there an exception to that rule because I died? Yes. There are about 30 exceptions to the hearsay rule. So basically, this is when another person is coming to testify about what they heard somebody else say. Oh, I hate this chapter because it's really hard to explain. But hearsay is inadmissible unless there's an exception. And like I said, there's more than 30 exceptions to the hearsay rule. So like, why even have a rule if there are 30 exceptions to it? I don't know. That's why I'm not a lawyer. Anyways, rulings on evidence cannot be assigned as in error unless there are substantial rights affected, which is, again, very confusing because judges have discretion. Remember that? And the nature of the error was called to attention of the judge to alert him or her to the proper course, and the judge did not take corrective measures. Again, we'll keep moving, all right? In some states, each time that the evidence is offered or referred to, the opposing party must renew its objection to the evidence. So, if there's some piece of evidence that I, as a defense attorney, don't want to be referred to in court, and the judge says it can be referred to in court, every time it gets brought up, I have to say, I object, I object, I object, I object. Super annoying and time consuming. I'm gonna skip this. Blah, blah, blah. I'm gonna skip this too. I'm not gonna ask you about this. Yep. I'm still skipping. I'm gonna go back here though, but what I do want to mention is something I don't think we've talked about yet though, is what is evidence? What can be evidence? What is an example of evidence? Can a statement be evidence? Can your cell phone be evidence? Can an eyelash be evidence? Can a piece of gum be evidence? Can your dog be evidence? Can a pillow be evidence? Can a bullet be evidence? Yeah, anything can be evidence as long as it's related to that case, relevant to that case. Yeah. So when we're talking about evidence, it's something that proves or is meant to prove what you're trying to prove in that case. And it can be a statement. It can be something written. It can be a written document. It could be a banana. It could be anything. Okay? All right. Judicial notice. So this is an interesting one. Concept of judicial notice is used when a relevant fact is so well known that it requires the time. Basically, it's a waste of time to prove. To prove it would be a waste of time. So, like to say, let's say, to prove that the sky is blue would be a waste of time. Although the sky isn't always blue. Let's say, I'm going to say that most of us, if you live in the city of Fresno, and you are familiar with the area of what we call Sin City. This is kind of over by Fresno State, Bulldog Lane, 4th, 5th Street, Bulldog Lane, Barstow-ish area in there. A lot of people know that that area does tend to, unfortunately, have a decent amount of gang activity. So a lot of times, if there is a trial that's going forward and someone is trying to prove that that's an area that has a lot of gang activity, they will ask the court to take judicial notice that that area is known for a lot of bulldog gang activity. And the judge will say, you know, if both sides agree to this, I will take judicial notice, as opposed to the prosecution having to put hours of evidence on to prove that that area has a lot of gang activity. Does that make sense? I hope it does. That's the hard part, again, about teaching online, is that I cannot ask you in person if that makes sense. But judicial notice is just that. Generally known within the territorial or jurisdiction. And both sides have to agree to the judicial notice in order for it to happen. So most times the both sides want to move forward. They don't want to waste time proving something that everybody knows. Everybody in the courtroom already knows this, including the jury, judge, and both sides. So, and then as far as evidence is concerned, the evidence has to be relevant to the case. So you can't be bringing in a banana that has nothing to do with the case and then trying to prove that this is a banana. Does that make sense? Yeah. Anyway, so the evidence in a case needs to be relevant to the case. If this is the banana that has the fingerprints on it of the person who ate it and is also the person that killed the person who lived in that house, then yeah, then it's relevant evidence. But if it's just a banana from the grocery store that has nothing to do with the case, then it's not relevant. Waste of time, and waste of time. Character evidence. So a lot of people would think that, you know, maybe we should have, you know, our best friend come and testify and tell people what a great person we are, so that the jury will think that there's no way we ever could have done such a horrible thing. Or what I used to see all the time was your mom. I worked in a juvenile court, and, you know, you would have little Johnny accused of, you know, doing a carjacking, and then his mom would come up and say, well, little Johnny was with me, and he would never do anything like that because little Johnny is a good boy. I literally cannot tell you how many times I heard that in my life. But that's called character evidence. And it's not admissible to prove conduct, exceptions, or other crimes. It's very often used at sentencing, but to prove a crime, not necessarily. Okay. Rape shield laws. These are laws that have been put into place to protect rape victims. Before they were put into place, ultimately what was happening is that rape victims were basically put on trial and victimized all over again. The defense team was asking rape victims, what were you wearing that night? Didn't you ask for it? How many drinks did you have? Isn't it your fault that you got raped? Things like that. How many sexual partners have you had? But there are laws now that have been put into place to protect rape victims so that they are not basically dragged through the mud every time they have to go to trial. Yeah, even if they were prostitutes. A lot of times prostitutes got it especially bad in court because they would say, well, aren't you a prostitute? How can you rape a prostitute? And these women were being victimized over and over and over again. So, witnesses. There's no mental or moral qualification for testifying as a witness. Interesting, huh? There is competency, young children, and competency issues. Every person who is competent to be a witness can be a witness. It's really hard to have a young child come up and be a witness. I've seen prosecutors bring young children in who were victims of sexual abuse, and it's very difficult. A lot of times the judges will interview them and see if they understand the difference between right and wrong and things like that. It's actually really sad. Witnesses, we have expert witnesses, and then we have lay witnesses. Non-expert witnesses, they are basically people who would have had specific knowledge of the actual crime. Witnesses are sworn in. Did we talk about expert witnesses? No. Okay. Witnesses are sworn in. Do you solemnly swear that you are about to tell the truth, the whole truth, the truth, the whole truth, and nothing but the truth, so help me God. And then you say, yes, I do. And why do you think they do that? Witness is required to declare that he or she will testify truthfully. Do you think that keeps people honest? Because I'll be honest with you, I don't. I have seen people lie on the stand. Why do you think we still waste our time with this? And I'll tell you, there's a good answer for that. So these people who lie and are proven to be liars can be charged with perjury later in time. So that's why they do that. Witnesses can be impeached or basically found to be lying. Their credibility can be attacked later. They can be convicted. I'm just kind of skimming. Okay, I knew we were going to get to the lay witnesses and expert witnesses. So lay witnesses are people like you and me who typically are people who actually witnessed the crime or had something to do with the people who committed the crime. Maybe were involved in some way or another. And then you have expert witnesses who typically were not involved with the crime, who probably weren't even there, but they have some other type of expert information about gunshot residue, fingerprints, DNA, things like that. So typically you're going to have your lay witnesses, just like you and me, and then you have your expert witnesses, and those are people who are experts in some sort of field where they didn't necessarily witness or have any contact with the crime itself, but maybe later they were involved in evaluating evidence, things like that. So, and there's pros and cons to this because expert witnesses typically get paid. So it's obviously whenever there's money involved, it can kind of lead to the whole concept that maybe people get biased, but I don't know. And their opinions sometimes, and it's kind of everything gets kind of muddy there. But anyway, so there are two types of witnesses. Basically, you have experts or lay witnesses, and non-experts that's what that is. Original documents, typically you're going to require original documents if it is evidence in court. Blah, blah, blah. Oh, this is something that's really important. Okay, one more thing about evidence. Okay, one more thing about evidence. And I'm going to tell you, yay, I know you want to hear a story because that's everybody's favorite thing. Okay, I'll tell you a story because we're 19 minutes in and all you want to do right now is listen to my story. But it's important because it talks about the chain of custody. Chain of custody is absolutely ridiculously important. When you have a piece of evidence, actually, I'm not going to tell you a story because it's too long, but it is really important that that piece of evidence, whatever it is, every person that touches that piece of evidence has to document when they touched it, where they put it, who they gave it to, and where it went next. And I am going to, okay, brief story. As a probation officer, I used to drug test people, and I would do it at my office at Hoover High School. Sometimes I would lock it in my office and I would leave it there overnight. Who do you think had access to my office at Hoover High School? I'm guessing that maybe the janitor did. I know that the principal of the school had a master key. Not that anyone really wanted to come in and mess with a urine sample, but you never know. Then I took it back to my office at the probation office, and then it was in a lockbox that everybody in the building had access to the key. So you can imagine how ugly it would have been if I had tried to take that to trial. Then we would put it in a UPS bag, and we would sit it on a counter, lay it on a counter, and wait for the UPS guy to come. Again, chain of custody, how clean was that chain of custody? Not very. So that chain of custody is really important with evidence. Don't be that police officer that's sloppy and doesn't watch their chain of custody. Because I'm telling you right now, what I did was not good. So, summary, blah, blah, blah. Whew. Long chapter. Sorry, guys.